Hey there, everyone. It's Rob Ryder. It is Sunday, September 15th, 2019. And today we're going to talk about proceed by bill of complaint in Chancery and protect the faith. And so here, Chancery is a division of the circuit court. But some places, it's its own separate court. In Michigan, up until 1846 or 1848, we had a Chancery court, and then they combined it with the circuit court, and they said the one court would have all the jurisdictions. Right? And but to get to it, you got to follow a particular procedure. It looks like, and that's kind of what this video is about. Is really just looking at things that people already might have some familiarity with and understanding. Well, if you don't call something the right thing, they can say that that's not what you said. Right? So if you need to call something a bill of complaint, and you're calling it just a complaint, well, that may not be good enough. And somebody like a clerk could say, well, I wasn't sure what you were talking about. So, how do you, what's the proper name of something and what's the proper pleading style to use to invoke that jurisdiction? So, we're going to look at some of that stuff. Um, but what you could use it for are things like acts of bad faith, right, that are being done against you and your property taxes, titles to land, everything to do in commerce, traffic, your estate, and criminal. Because whether you know it or not, when you go to court for anything or you get your property taxes or whatever it is, it's all being done in bad faith by people acting in bad faith, whether they know it or not. And this is how you get it adjudicated is, they maybe think they're doing it perfectly. In fact, if you talk to people at the county or wherever it is, and you catch them on something, and they say, yeah, but we've been doing it this way for 20 years. I've been here for 30 years. We've always done it this way. There's all sorts of people have told me that's what they've been told by the counter trolls. And it is. It's what they've been doing. They believe it's done properly. But they're not the court, right? It isn't their decision. They're the ones you have a dispute with. So where do you take your dispute that something in bad faith is happening to you? Well, as it turns out, it looks like you take it to the Chancery Division or Court of Chancery, if that's what you have. And you file a bill of complaint. And because federal courts have both law and equity jurisdiction, I think you can file a bill of complaint there, but you got to call it a bill of complaint. Tell them you're going to the Chancery Division of their jurisdiction. So let's take a look at some things. That was the plan, right? I was going to look at some things that led me to this conclusion, and over the next week or so, I'll get a few more details put together and ask some more questions and try to pop a paper or two into some place and see if it makes a difference in these type of areas, right? Property tax, title, commerce, traffic, estate, criminal. It doesn't really matter. It's just how much trouble is it worth to file the paperwork. And how do you file the paperwork? And is there somebody to go talk to that could give you legal advice about filing the paperwork? See, I think if you were to tell a paralegal, I want you to write me up a bill of complaint to file into the circuit court in Chancery Division, well, they would know what that meant and they would know how to write the paperwork. But that isn't what we're asking people for. We're going to talk to attorneys and agreeing to let them represent us and basically sign our name for us. They just act like an attorney in fact instead of giving you legal advice. But if you knew what it is you wanted to put in, well, then they might be able to do the rest of it. And so I just think it's this idea that we need to be filing bills of complaints or petitions, as we'll see, into Chancery. Before we get there, though, hey, your donation is participation when we're working for the common good. And that's what I do every day because I don't own any property. I don't have any property taxes, and I don't have a title to any property. But I still think it's worth figuring out how to do because most people do. And this is how you get the world out of the devil's hands and put it back into Christ's hands. You got to go claim the estates, and put them into the proper jurisdiction. And they're not there right now, and they were taken out of the proper jurisdiction by bad faith. So let's put them back in. So if you can donate, please do at PayPal. You could do it to Rob Ryder at AOL.com. That's my PayPal name. You could email me for a bill for opinion, and I'll give you my opinion. Charge you something for it, and you get the bill, and you could use your credit card that way. It'd still be going through PayPal. It's just a way for me to send you something and have you pay by credit card instead of you needing to use your if you don't have a PayPal account. Or you can send it by, snail mail, Robert Allen Rutluski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. If you want to email me your questions, though I prefer you did it to courtofrecord at AOL.com, COURTOFRECORD, no S's, and AOL.com, because other people use court of record, like Gmail, probably Yahoo, probably a whole bunch of them. And my phone number, 616-712-6179. So, hey, I'm not hiding. It's where you find me. Today we're going to talk about proceeding by bill of complaint in Chancery. And look at the things I saw that make me say, well, this is worth going to try. And now, that's what I do. I look for something to try, and then I go try it. Well, right now I'm at the point of looking for the thing to try. And I did already in my case I have going in the Veterans Court, because the law that I was looking at there, so I have a court case going in the Veterans Court right now. And you get to a certain point and you can file this thing they call an Equal Access to Justice Act application. EAJA, Equal Access Justice Act application. And it's governed by this statute here, which is for cost and fees. It's 28 U.S.C. 2412. And in here it talks about acts of bad faith done by the United States. So, well, that's what they did to me. I had acts of bad faith because I'm saying that they're acting in bad faith because they won't give me my unemployability status. And that it's, the not so much the United States, but it's the VA that's not doing it. Because I had to have this court case in, and through the whole time I had it in, they never found one piece of paper. And yet the court went ahead and mandated that it was closed, And so I just said, well, that's in bad faith. Well, that got, things to roll a little bit further, and I'll talk more about that at some other time, but it's too many things to mix together. Right now, we're just going to get into, because that's really kind of specific. I just want to stick to some generics. But in the Supreme Court now, right, where they say they don't have jurisdiction in faith, they still have motion to leave to file a bill of complaint, which is something that's done in Chancery Division. So it could be, even in the Supreme Court, it's a matter of getting them into the right hat. Call the thing what it needs to be called, and then they can have some jurisdiction over it. Because then they don't have to call it a matter of faith, although it has different names than just matter of faith. First, you have to get it in the right hat. And I wanted to point out that they had this thing, this is from like 1850, where it talked about the royal supremacy, not an arbitrary authority, but limited by the laws of the church, of which kings are members. And this is written in England by people, canon for Christ Church, who, this was the Church of England talking about its role and what was happening in the Church of England, which has its own courts. So what he was mentioning in here, without getting into all of it too deep, it'd just be interesting to read, that the Christian emperors claimed to themselves no authority in controversies of faith. That's actually in the Articles of Religion written by Henry VIII, right? The church hath authority in controversies of faith. And appeals of clergy from the bishop, lay to other bishops, or a primate or general council. The civil magistrate might nominate episcopal judges. To appeal otherwise to a civil court was prohibited on pain of degradation. Right? So if you were going to go to a civil court, you had to go to the episcopal, bishop judges, basically. Right? Who did the judge nominate to be their judges? And so that would be like going to the court of Chancery. I just believe that's what they're talking about. And the principle that ecclesiastic offenses could only be tried by ecclesiastical courts was formally admitted into the Theodosian Code and became part of the civil as well as ecclesiastical law. And so a lot of these things all happened because it was based on old Christian law, sure enough, Christian emperors. And after Henry VIII kicked the Pope out, he had to base his legitimacy on something. So he said, I'll go back and look at what Theodosian did and Justinian, and those would be the parameters that I'll run the country under. And so it wasn't just arbitrary law. No, it was, agreed to that the royal supremacy was not an arbitrary authority, but limited by the laws of the church, of which kings are a member. So the king has to have a conscience. And that was found in the Court of Chancery in England. So let's get into some particulars here in just a second. I need a second to load something up. Okay, well, this has to be a good one to start with because this affects anybody who thinks that, that you own a house. Because the truth of the matter is they've never transferred the title to you. The title is not quiet. Right? And so if you wanted to quiet the title, well, how would you do it? Well, in Michigan, it's MCL 600.2932, which says any person, whether he is in possession of the land or in question or not, who claims any right in Title II, equitable Title II, interest or right possession of the land may bring an action in the circuit courts against any other persons who claims or might claim an interest inconsistent with the interest claimed by the plaintiff, whether the defendant is in possession of the lands or not. So whether you're in possession as the plaintiff and the people you're going against are in possession as the defendant, it doesn't matter. You could still bring a charge. But because they have never quieted your title, right? This is how you get it done. You would have to bring an action in the circuit courts. Again, this is Michigan. And further in here it says, and the actions of this section are equitable in nature. Well, then you have to bring it into the circuit court in equity. Well, that would mean you bring it into the circuit court in Chancery division, because Chancery is equity. So no action may be maintained under this section by a mortgagee, that'd be the people that said they lent you the money, his assigns or representatives for recovery of a mortgage premise, until the title to the mortgage premise has become absolute, or by a person for recovery of possession of premises which were sold on land contracted to whom relief is available under subdivision 1 of 5634. So there are times that you couldn't do this, but how you find out? You do it and see if they take it. If they do, well, then I guess you could, right? Let them tell you can't do it. You should find every opportunity you can to say, hey, that's mine, and tell them and see if they'll agree with you. Because if you can get the court to agree with you that it's yours, well, then your problem is solved. So let's get the court to agree. If the plaintiff established his title to the lands, the defendant shall be ordered to release to the plaintiff all claims thereto. In an appropriate case, the court may issue a writ of possession or restitution to the sheriff or other proper officer of any county in which state, which the premise recovered are situated. So, for instance, you don't need to be in foreclosure to do this, but let's say that you are in foreclosure. Well, then it would be time to do it because you're running out of time. And you would need to go to the circuit court and file a bill of complaint in the circuit court, in Chancery, to have them quiet the title. And your evidence that you have the title is the fact, not really the warranty deed, because the warranty deed will come into play, but on the warranty deed is a revenue stamp that's not been canceled. Right? That's the big deal on that. They never canceled the warranty or the transfer tax. So they collected the money, but they never paid it to the state. They never transferred you the title. And I had told this to a guy in Florida here a few months ago that was on his, who was going into the court the next day. I said, you need to take that in and tell the judge. Well, he went in and told the judge that his warranty deed had a transfer stamp that hadn't been canceled. And the judge said, well, let me see it. And the dude forgot to take it to court. You know, but the judge wanted to see it because that would have been something that he could have said, well, there's something there, right? That the judge could put himself into equity jurisdiction, right? That one way is you put him in, the other way is he puts himself in. Well, he was going to, put himself in equity jurisdiction and take recognizance of the fact that, that the transfer stamp hadn't been canceled, and the law clearly states that it has to happen. Anyways, I had found this, and I said, well, okay, well, this is something you should be able to use. But then it got a little better, because in the, I gotta find it now, Teepers. Let me see, where are they all? Let me go find it. It's just a little bit too hard to. Okay, so this one law, which would be MCL 62932, right, gave some clues. Then there was this other one, which was loss or destruction. So I found this act, right, which is another MCL. So now it's MCL 561-1-2, where it talks about public records, loss, destruction, order of appearance, hearing, property description. When public records in the Office of Register of Deeds of any county have been or shall hereafter be lost or destroyed in whole or in material part by fire, flood, or disaster, the circuit court in Chancery for such county shall have jurisdiction and authority to hear and determine any suit instituted under the provisions in this act, and the rights of the several parties in the said suit. So now it said not just the circuit court, but the circuit court and Chancery. To do what? Basically to quiet the title. So it shall be the duty of the prosecuting attorney of such county, when directed by the Board of Supervisors of such county, to file a bill in Chancery on behalf of the people of the state of Michigan and for the county to determine and quiet title in and lands of said county. So how do you quiet a title in the county? You file a bill in Chancery. This is for, if all the records get destroyed, right? So that's, everybody, but yours is a particular case. Because, you can look at yours and say, well, mine's not been transferred, right? The title isn't quiet because my revenue stamps haven't been canceled. And so we're going to look at that in just a minute, but I'm just showing you that it goes on now to say, well, this is how you do it. You go to file a bill in Chancery, right, into the circuit court in Chancery. And then it's, well, what kind of bill is it? Well, it's called a bill of complaint. Right? So upon filing the bill of complaint in the circuit court, I just told you what needs to be done. You got to file a bill of complaint in the circuit court in Chancery. Well, then eventually I'll actually show you what it would look like. All right, state of Michigan, in the circuit court for the county of Kent in Chancery, or whatever county you're in Michigan. That's the title of your freaking paper. Right, state of Michigan, NRE petition to establish quiet title lands, public records, that blah blah blah. So after this now, because you're not doing it as the state of Michigan, you're doing it as you, well, then it would have different wording. But the idea is that this is the heading on where you need to put to have it get into the right jurisdiction. Right? Put it in all caps, state of Michigan in the circuit court for county of Kent, or whatever county you're in Chancery. And when you give it to the clerk that way, it'll get into the right jurisdiction. Otherwise, it's going to go to law or criminal first, both of which you can't go to until you've gone to the bishop, right? Or you won't have been a Christian, right? You won't have followed the Christian code and gone and had your matter adjudicated, because we're making it a matter of faith, right? And that's what's happening in Chancery. So that's why we need to go to that particular division of the circuit court, which has 3 divisions: Chancery, law, and criminal. Well, very good. So, that's high quality title. You got to go to the Court of Chancery. What do those things look like? Be good to know. Where do we see one? Oh, hang on here. There we go. So now I don't know exactly what this is. This section is from a book, The Law of Land Contracts by Asher L. Comelius, Comelius. You might want to Google that to find this yourself. Section 232, bill of complaint can be drawn in the following form. Form of a bill of complaint. State of blank in the circuit court for the county of blank in Chancery. John Doe and Mary Doe. Plaintiffs versus whoever this is. This would be your full legal names. If it's you and your wife, so be it, right? Robert Allen Ritluski and whatever my wife's name is. But nobody in middle initials. You use your full legal name. And it doesn't need to be both of you. It could just be one of you. You don't have to have the other one's permission to go, save your property. Plaintiffs versus whoever Richard Rowe is. So this is, is this a tax thing? Is this against the treasurer? Or is this against the attorney that's taking you into a foreclosure? Right? Whoever it's against, because we're going to make it a matter of faith. And get the court to quiet the title. Right? To the circuit court for the county of Kent. So if you ever notice, a lot of times they'll say in the circuit court for the county of something. Well, that would mean it was already there. And this is how you get it there. This is the 2. Before it's an N, it had to be a 2. And this is how you do it, by making a 2, the circuit court for the county of blank. Right? And who the plaintiffs are, da-da-da. So this is the part that needs to be worked out, is what are all these words in here? But then I had another thing at the end. Right, that the plaintiffs further show that the defendant is attempting to sell and dispose of real estate, secured, plaintiffs, credited, da-da-da. Where's my part I wanted? Where is it? I think we just go to the end. Okay. That the people's writ of injunction may issue out of and under the seal of this honorable court, restraining the defendant from selling, assigning, or otherwise. Right, so get an injunction. So that's what they're asking for here, is what are the things they want to have. Make a full and perfect answer to all singular matters hereunto stated or charged. Right? So you put your adjudicated facts in that you want the court to get an answer for. And then, so this is in the state of Michigan. It has on this particular day, before a notary public in and for said county personally came and appeared, named plaintiffs, full legal names, and made oath that they had read the foregoing bill and complaint, by them subscribed, and that the same is true, except as to the matter stated upon information and belief, and as to those matters they believe it is true. Notary Public, Wayne County, Mich, M-I-C-H. Right? This is, a particular style of an attestation to be put on a document, and apparently this is the one that you would use for a bill of complaint because it says it is right in the frickin' attestation. So there's the attestation. Here's the introduction. What goes in between? Well, your set of facts and what you're complaining about. So you would say, well, you can figure that out, or, you would know what to go ask an attorney. Tell him you want to do a bill of complaint, and here's the things I want to complain about. Have him write it up. Right? But whatever it is, make it a bill of complaint going into the circuit court in Chancery Division. And if you do that, you'd be styling or profiling. You'd be in the right door. Okay, hang on a second. Got some more. Okay, then, sticking with the real property theme. In Michigan, they have a thing called the real estate transfer tax. Right? And they put these documentary stamps on the document, and then they're supposed to be canceled. And that's according to MCL 207-507, documentary stamps, purchase, methods of fixation, and cancellation. Right? The tax imposed by this act shall be evidenced by affixing a documentary stamp or stamps to every instrument subject to be tax imposed by this act by the person making, executing, issuing, delivering such document. Documentary stamps shall be purchased only in the county in which the property is located. The stamps shall be affixed in such manner that the removal will require the continued application of steam or water, and that persons using and affixing the stamps shall write or stamp thereon his initials and the date upon which the stamp was affixed or used, so that the stamps may not again be used. The treasurer may prescribe such other method of cancellation as he deems expedient. The treasurer shall, if required by state treasurer, utilize a tax meter machine, which shall be provided by the county. And so what they're doing then is they're putting these damn little stamps on the document. Right? So this is a quitclaim deed in Michigan that has this revenue estate or revenue transfer, real estate transfer tax stamp. Right? Then it's got these dots right here. And then, that's the end of the stamp. There isn't anything over here. And whether that's somebody's initials or not is to be, could be argued. I say that hasn't been canceled properly. Right? And they didn't date it. See, it says initial and date. They didn't date it. It's got the date when it was bought. It doesn't have the date when it was canceled. And that's what they said to do. Put the initials and date on it. In the fucking law. Excuse my French, but, follow the law or I'm going to complain. So, right? This is an act of bad faith because it's the thing that proves that the tax has been paid. The proof the tax has been paid is the fact that it has a canceled transfer tax stamps on it. Now, the thing is that this is a warranty deed, which isn't necessarily the legal title, but it's more like the equitable title, where the interest is being given to you, but the legal title is actually given to you by the buy-sell agreement. I don't know if I got those on. I got some on here, didn't I? Yeah. So, right. So here's a case in, this is Terry's in Wisconsin. She's in a foreclosure, so I'm sure we'll be doing something in her case here in the next day or so. Where she had a counteroffer in, so this is where the signature showed up. But that these documents, it's the buy-sell agreement that is the only document that has more than one party that signed it. Right? So this is like the addendum to the buy-sell. It's the counteroffer. But it's got the seller signature and the buyer signature. Except this is actually like an electric signature, right? And then this is the actual residential offer to purchase. So if you were buying a house, you have one of these or had one of them, and it says all the things that are going to happen. Supposed to be $500 mailed to somebody, right? For earnest money. That's what the earnest money is. But if you went through this, and I had done videos before on this, that there's just certain things that they have to have done that if they're not done, well, it's bad faith by your real estate agent because you had an agent and the agent owes you a fiduciary duty to have done these things. And part of it is like transferring the title to the property. So where is that at? Where's transfer title? Oh, title evidence, so forth and so on. Well, part of that title evidence would be there that you have this receipt in Wisconsin that shows that the real estate fee has been paid. And Terry never had that. Every county's got some kind, or every state has some kind of, contract. The style they're using in Illinois. And if you go to the 13th page, right, got a place for seller signature, buyer signature, seller's brokerage, buyer's brokerage, who's the agent, right? Signature of the loan officer. It's got all this information on there. Right? So one document ties everything together. You wouldn't find all this anywhere except on this document. And this is what really is transferring the legal title. This should have been recorded just like the warranty deed, right? It's a document that conveys interest or title, is what the way the law reads. And so this should have also had been recorded, but it never has been. So I'd be taking all this information together and taking it with my bill of complaints in Chancery to the court and tell them that, they, by an act of bad faith, your title has not been transferred to you. Here's another style. This is what they use in Arizona, right? Residential real estate purchase contract, right? You could say they didn't use my full legal name. That would piss me off right to start with, right? That's not my name. It was wrong from the beginning, but I'm claiming it's mine, even though that's not my name. So let's just get it figured out. I'm the one that bought it, right? So let's get it figured out. And that's what, if they had done all of the things that are in here, like title and escrow, if you read all these things, if they had done them, well, then you'd have the title. But they didn't do them, so you don't have the title. Well, they owe you a fiduciary duty because they're an agent. They have an agency relationship with you. It's just your buyer's agent hired another agent, a closing agent, to do the work, and the closing agent has a fiduciary duty to the buyer's agent, but not necessarily the buyer. Our beef is with the agent, right? The real estate agent. And by that I mean the broker, because you need a broker's license to actually do the transfer of the property. Right? You can't do this stuff unless you're a broker. So it's their fault. Right? So I'm just showing you, go find these documents, right? This is the first thing you want to do is go find this, whatever state you're in, and read it. And say, okay, what do they need to do to transfer title? Let me read all this, and let's go find everything that they're talking about and put them on the table and see if we have them. If we don't, say, well, I guess I didn't transfer the title. Right? Or go look in your state's laws and find out, well, what do they do? For these records. So, okay, hang on a second. Okay, then, so, hey, if you're in Michigan, you're going to want to write this down, right? Act 52 of 1944, and just take a minute to read it. This is where they talk about, filing a bill in Chancery and so forth. And also MCL 600-2932. And if you're not in Michigan, well, you're going to want to put in, whatever the name of your state is, quieting title, interest of plaintiff. Put in some keywords and see what comes up. and find your version of it. But a little bit more on these things in Michigan then. So, because this also would apply to your taxes. Because if you look at your tax notice, right? So again, you don't have to be in foreclosure for this stuff to be of interest to you. If you look at your tax notice, you'll find that they're not using the same style of name, and they don't use the same legal description, right? Like the property number or whatever it is that is on your warranty deed. Well, if your warranty deed is supposed to show your interest in it, and it's like, well, that's what you bought, right? What's on the warranty deed, then why are you paying taxes for something that isn't yours? And so, yeah, what they did is, it's like this is a property number here, which comes off of a survey, right? Blue Lake Township, right? So this is at the township level. It's Township 002, Section 34. And then what we're looking at is then, you can't read it because it's greened in, but it's 005-00. Right? But this only goes to township level. It doesn't go to the county level. And if it was at the county level, then there would be a 40 because that's the county number of Kalkaska County. But they failed to put it on there. Well, how was the property bought in the first place? Right? Sirens going down the road, but there's some sirens, so you just have to put up with it for a minute. Let's see. See, this was quit claim to Dana R. Smith. And here's the legal description, right, with the property stamp that hasn't been canceled. But this legal description that's on here doesn't necessarily match what they put on here, right? Because this says it includes these other parts. You know, it's got one with a 01 at the end and then one with a 15. So 00500, right? That's the first one. And then it says, and includes these other ones. But when you look at the survey map, that's not what they greened in. It's just 00500. Where'd these other numbers come from? Right? So they're charging him a tax on something that, you know, according to the tax man that gave him this from the Kalkaska County Equalizing Department, right? That, oh, this is what you own, 00500. But they're taxing him for what's that tax bill? With these other ones on there. Now, how did this go together? Because this is the guy that was buying it. This is the guy that Dana bought it from, buying it from the guy before him. Right? So on here on the second page, it says what the tax parcel number is. It starts with a 40, 002, 034, 00500. Well, how did that tax parcel number go to this tax parcel number? Right, to this tax description with a different property number, with Dana's name backwards, right? That isn't the name of the guy that bought it. It's Dana R. Smith, not Smith Dana R. There's no comma in here. This is just the way they got the guy's name. Smith Dana R. Say, well, that's not my name. So, you know, if you really look closely and read word for word what your warranty deed says compared to your property taxes, you'll soon find that they're, you know, taxing a different name and a different property description than what you purchased. Well, that'd be an act of bad faith. Who are you going to take it to? Well, apparently that's what we're supposed to do. We're supposed to be taking, you know, these types of things to a court of chancery. Or Chancery Division of the Circuit Court. Because that's what, they were transferring to the guy that Dana got it from. But when Dana got it, they changed the frickin' numbers. Where's that at? Where's he got that on here? In fact, I don't think they put it on. Right? They didn't even bother putting the number on there. So, who did this and why? I don't know. It's just, again, these are all the errors that are in people's records that we need to go have we got to have the frickin' title transfer. The title quieted. Okay, so, next week I'll have more to tell you on these. It's just, I have a couple to work with that we'll start with to see if I can find out what to do with them. But it's going to be filing something into the Court of Chancery, into the Circuit Court in Chancery, and see if the clerk takes it as that and, begins the process. Okay. Okay, hang on just a second, please. Okay, so let's look at one that would have to do with the estate. I'm sure that's of interest to people. One of these other laws I found was this is MCL, Michigan Compiled Law 600.2936, probate in chancery of foreign wills, proof by copy, legal representatives, bill of peace. Wasn't that interesting? I'm just going to read number 2. So whenever any person appointed by a probate court as a legal representative or trustee of the estate of a deceased person, a minor, or a mentally incompetent person has possession of over 100 worth of the estate's real or personal title or personal property or its proceeds and has good reason to doubt his right to hold or dispose of the property because of adverse claims of title or lien or other persons or corporations or of conflicting proceedings to administer the estate in that or another probate court, and no proceeding having been taken to test his right by adverse claimants or otherwise, he may file a complaint in the nature of a bill of peace in the circuit court of the county in which they're located, the probate court which appointed him to have adjudicated the validity of his own right and the rights of adverse claimants and legal representatives appointed in conflicting proceedings. All that to say, right? Like on my certified copy record of birth, it's got a section there where it talks about the child, and it's got my name, and it's got, where the record is kept and so forth. Well, that's my minor. Right? Now, when I was a kid, well, I wasn't the legal representative of that because, I wasn't of age. But now I am. So I can be the legal representative of my all caps name. Right? I'm its owner. I'm not its trustee. I'm its owner. So I'm going to claim it as a legal representative. How do I legally represent my property? My business, my all caps name? Well, I'm its owner. And I've done that by filing with the IRS to get a EIN number using my full legal name, Robert Allen Rytlewski, as the name of my business, and the owner, Robert Allen Rytlewski, with both having the same address, everything the same. As I remember, right? Did it on the IRS website. You can do it for free. Use your Social Security number as your right to do it, because you can only have one as a sole proprietor. And if you don't use your full legal name and you've got an EIN as a sole proprietor, well, then you just have to change the name of your business. But you can have a business in your name and get an EIN number for it as a sole proprietor, which I did. So I'm the legal representative. But I've never had it tested. Right? I never had my right tested. So I got to, do a little bit more on what this bill of peace is exactly. But again, it's, that's what you call the document so that they know what it is. And then you say on it whatever you're going to say and, ask them to do the right thing. And hopefully they give you a remedy. So I think I need to take and send to the Circuit Court of Bay County, right, which is where the documents originated from, and see if I can quiet the title, more or less, right, Bill of Peace, and claim to be, the authorized representative of myself. Jeepers. Hang on just a second. So this will be something I'll be doing here real soon, right? Either it says file a complaint in the nature of a bill of peace. So do I make it a bill of complaint in the nature of a bill of peace, or do I just call it a bill of peace? I don't really know yet. See what we can figure out. And send it to my birth county with a copy of my EIN paperwork and say, hi, I'm the owner. Would you go ahead and, prove my claim? To see what they do. So that's the estate side. And then just because I was looking at all these different things that came up, it's like, well, I had looked at a number of court cases. What I had done is went to the state's website to look at, while I'm talking, go ahead and write this down if you can, send me a donation. I was looking for different places where they used, the words such as Chancery or bill of complaint, as they found these different words, and see where they showed up in different opinions or whatever in the state. And I found a nice one here. This is a syllabus from the Supreme Court of Michigan. And, there's a long-ass thing about something in probate, but it was all the other stuff they added to it. Again, I was just searching on things to do with Chancery. And so I had this section here on State of Michigan Supreme Court, the dissenting judge, that said the majority holds of the Government Tort Liabilities Act's grant of immunity to governmental agencies from tort liability, as referred to in some MCL, applies to civil contempt. So, right, the court said that civil contempt is considered a tort. And under this Government Tort Liabilities Act, well, that's where they get their sovereign immunity. So, if it isn't anything else, first, it can't be a tort. Right? So you can't let it be called a tort. That would be the thing. If it's called a tort, if they can call your action a tort, well, then they can say it was, Government Tort Liability Act. Oh, we got immunity. So what are things that aren't torts that you could get them for? Right? So let's just read a little bit more. First, the majority's analysis rests entirely on two closely related propositions. First, the GTLA grants immunity from legal responsibility arising from a tort. She agrees with that. I agree, whoever this is, McCormick. Second, all non-contractual civil wrongs, including civil contempt, are torts. So, all non-contractual civil wrongs, including civil contempt, are torts. Which would mean then that all contractual civil wrongs aren't torts. Right? Only non-contractual civil wrongs are torts, including contempt, as she said. But she disagreed, or he. Civil contempt does not sound in tort, and contempt sanctions of any kind simply do not impose tort liability. Furthermore, and not surprisingly, the GTLA does not provide any basis concluding that our legislature intended to grant immunity for contempt of court. So apparently somebody, claimed contempt of court, and then the defendant claimed immunity for being the government. And it went to the Supreme Court, and the majority said, yeah, they're immune, but this person is saying, well, no, you're not. So there's things to be learned from, what this dissenter had to say. So let's look at it here. Very generally speaking, there are two categories of legal wrongs that may result in civil liability. One category encompasses acts that violate a personal right, citizen on citizen, common law subjects to property, tort, contract, trust, restitution. A second category encompasses acts not against the person, but against the sovereign. Oh, that would be against the state. Well, those would be crimes, right? When you violate the laws of the state, it's a crime. But it's also civil liability. So it's not a tort. So my point is, you make it, that what happened, like in a foreclosure, you could do it anything. That the people that are adjudicating this thing don't have the authority to do it. That they're violating the laws of the sovereign, because the sovereign says if you want to be a judge, you have to take this particular oath. And they haven't done it. And they didn't use their full legal name. And the attorney isn't using the name that's on his license to practice in Michigan. And there's all sorts of acts of bad faith going on in a court case when they take you to court. On a traffic ticket, that they don't put down what laws you broke. They just write some words and partial numbers and so forth, and you're left to assume that, well, that means I broke this particular statute. But it doesn't really say that. You just, you allow yourself to be convinced that that's what it says, maybe. And then people that have, misdemeanor or felony convictions or charges against you, if you find the form that they're charging you with, which would be with the prosecutor, right, the complaint, or if they won't give it to you, that's fine too, but that's where you would get it. The complaint won't have a complainant on there. It'll have a complainant witness, but it won't have been signed by the witness. It won't have been signed by the magistrate. That's what they used on Dana. It was a complaint, said he broke all these particular MCLs for traffic violations. But at the end of the day, it wasn't the person that saw it that signed it as the complainant witness. And then the complainant witness didn't sign the bottom where it says for the complainant witness to sign and to swear it before a judge and have the judge's name. And none of that stuff was on there. All there was is off to the one side where it talked about the prosecutor and attorney, and it had somebody's initials in there. So the whole thing is, it's an act of bad faith. And it's not an act of bad faith against you. It's an act of bad faith against the state because it's a crime. And, this is how you could keep them from having these loopholes that they keep finding that as they, try to work their way out of a court case. So anyways, the majority begins analysis, examine case law, definitions of tort. Ultimately articulates this one: a civil wrong other than a breach of contract. Right? So a breach of contract isn't a tort. Well, it's a breach of contract for these people because they, for instance, like your real estate agent, right? They didn't file the contract. It's a breach of contract. It's not a tort now. It's just a breach of contract. And if somebody swore an oath of office, well, that's a contract. Right? So they've breached a contract. So it's not a tort if it's a breach of contract. So that's one way to get around having it be a tort. Say it was a breach of contract. For which the court will provide a remedy in the form of compensatory damages. But this definition offers little guidance because civil wrong is itself a term of art. It can mean many things to many people. Okay, but how did they do this? Many non-contractual civil wrongs that are not torts. So contractual civil wrongs are not torts, and there are many non-contractual civil wrongs that apparently are not torts. The English legal tradition recognizes courts of law, that would be the courts of Queen's Bench, and equity, the Court of Chancery. Though complementary, the two operated separately and independently. Our modern system has abolished these distinctions, but has adopted aspects and rules of both. Civil liability, sounding neither in contract nor tort, is not uncommon. A breach of trust, for example, has its roots in equity in the Court of Chancery. So, right, what's a trust? The trust is the oath of office. It's a trust. They violated the trust. Right? These things that people call trust, their real name is a use. They're not a trust, they're a use. They have a trustee, but it's called a use. But a trust is like the real estate agent has a license and only he can do this transaction. So you have to go there and trust them to do it right. And he didn't do it right. So it's a breach of trust. He violated his license. Right? An attorney isn't using their name that they said this is the name that they can practice in. Well, that's a breach of trust. So, these are things to call it other than the things that would make it a tort. That way there can be no denial that you came with a breach of trust, which is done in the roots rules are in equity, which is done in a court of chancery, which now in Michigan is the circuit court in Chancery Division. A trustee relationship imposes fiduciary duties, right? That's what an agent has. An agent has a trustee relationship with you because you have a contract with them. For there to be, a trust like a use, the trustor, the one with the property, had to sign an agreement with the trustee to give it to the beneficiary. Well, where's that contract? If there isn't one, then there wasn't ever that kind of trust to start with. Right? But if there is an agreement, then the trustee has fiduciary duties, the breach of which result in liability. Now, we could say they're taking on that duty when they swear their oath of office to uphold the Constitution and da-da-da-da, but we're saying they're not doing that. That's a violation of their trust. Because they're not, you're not being guaranteed due process. They don't use your legal name. You're not securing your person's papers, houses, and effects from unreasonable searches and seizures because they don't use your name, so you're not securing your person. And then they don't use their name, so you're not really sure who it is taking your property. And yet that's what happens. They take your property or your effects and so forth. So a trustee relationship imposes fiduciary duties, though trust law can be well understood as half sibling of contract law. It cannot be reduced to contract. A breach of trust stems not from a violation of the bargain for exchange, but rather from the duties arising out of the special relationship between the parties, agent and client. That is, it was not considered a tort, and at common law, the only available remedy was in equity. If it's a breach of trust, you can only get remedy in equity, they're telling you. Another example is provided by law of restitution and unjust enrichment. It is based on the principle of equity. It sounds in neither contract nor tort, yet it shares characteristics of both. Right? It is based on the principles of equity. And that court is the Court of Chancery, or now called, the Circuit Court in Chancery Division. And to go there, you need to take a bill of complaint because that's what they're looking for. Now, they also talk somewhere about bills of complaints and petitions, or petitions. I think it was what it used. And so, if you wanted to get a writ of mandamus and you wanted to file a petition for one, maybe the proper word then is to call it a petition for writ of mandamus, right? But you need to still be sending it to the Circuit Court in Chancery Division, so that it goes to the right place that can, give you the petition. But petitions and bills of complaint both go to the Court of Chancery. And I've tried to send petitions before, but I never called it, to the circuit court of the county of Kent in Chancery Division. Right? I never called it that. But that would be its proper name, apparently. Okay, tax and civil infractions and tax law impose civil liability in ways different from tort or contract. The obligations they impose serve to vindicate the interest of the sovereign. Right? So civil infraction would be you're breaking a law. And there's not really a satisfactory definition of tort, and it goes on and on and on. But at the end of the day, you don't want to have it called a tort like when you're talking about the government actors, because then they can claim to have immunity. So you don't make it a tort, you make it a matter of trust. Right? They violated their sacred trust when they not following the Constitution, or when they took an improper oath of office. Right? You tell that to the chancellor, and maybe that's how you get it into the proper venue. I'm sure, if this is going to work, it won't be that hard. If they're going to pay attention to it because you went to the right door, then, they're going to open the door up so you can walk in. But apparently it's pretty narrow, right? There's very few things you can bring to them. But there are some things that the only place you can bring it to is for a remedy in equity. And that's what happened on what they're talking about right here is what's happening on your buy-sell agreement for your house. Right? It's not a violation of the bargain and exchange. It's a violation of the trust between you and the agent who is supposed to make sure everything on the bargain and exchange was done. And it hasn't been done because you don't have legal title to your property. If you did, your warranty deed that's been filed in the county would have been canceled, and they would have put a copy of the buy-sell agreement in there because it's the document that conveys the property. And so because your property has never been closed, all your payments still go to equity or go to escrow. You're not paying off any debt. Nobody ever lent you any money. You don't have a contract with you and the bank on there anyplace. The bank never signed a contract with you. The only contract that has more than one signature or one party signature is the buy-sell agreement. Otherwise, there may be documents with your signature on it, but nobody else signed it, so it's not a contract to be used in business. But it could be used as a promise, and really that's what they're saying is you promised to pay this. Although when you look at the name of the of the borrower, it's not your name. They don't ever use your full legal name. I gotta say hardly ever. I think in Georgia they actually use your full legal name, but they do something else wrong. I can't remember what it is. But for the most part, like in Michigan, they don't use your full legal name. If I was on a warranty deed, whose warranty deed is this? Okay, here's one for Dana. Who bought this thing? Who? Right here. Warrants to Dana R. Smith, comma, a single man, comma, whose address is, some street, da. Right? Well, Dana R. Smith, comma, a single man, that isn't the name of anybody. That's a thing. Right? It'd be like his name is Dana Reed Smith. Dana Reed Smith bought it. You don't need to add anything else. But they did because they're making Dana, taking Dana from a person and making him a thing. And that's what they do to everybody. They you lose your personality and become a thing, and now your name isn't on the documents, and the title isn't quiet, and if you don't go and quiet the title, you're never going to be the owner. And the way to quiet the title in Michigan, by the law, says you got to take it to the circuit court in Chancery and ask to quiet the title. So this ought to be a lot of fun next week. We'll see what happens. Okay, I'm going to leave it there. Thanks for watching, and if you can, please donate, because I got a few bills of my own to pay between now and whenever we get these things in. But I don't think it'll be too hard to do. It's just a matter of writing it and having somebody who can take it down and actually get it through the door. And so while I don't have any money to try it other ways, if somebody wants to contact their attorney to say, I want you to file a bill of complaint into the Chancery Division of the Circuit Court and find out that they'll do it, well then, call me and tell me what they said. Right? Because I don't think we have to do this ourselves. We just need to ask for the right thing to be done. And if you told the attorney what you wanted done, well, they'd probably have to do it. And one way to find out is go ask one. So we'll see how it goes. Okay. Thanks for watching and have a great day. See you.